Hey guys, attorney Jerry Parisi here, and this video is an attempt to answer the question, how to win a credit card lawsuit in Georgia. And that's a loaded question because there are several possible outcomes when you're dealing with a credit card lawsuit, and whether you win it, I guess just depends on your definition of a win, right? So let me go over the possible outcomes and then get a little bit more in depth with them. So first, one of the most common outcomes is a default judgment, which is what you want to avoid. It means you lost, you didn't show up to court, or you didn't file an answer, and the plaintiff gets a judgment by default. This is usually what they want, so you want to try to avoid that. Second possible outcome is entering into a settlement agreement, and depending on the facts of the case and the settlement agreement that's in place, maybe that's a win for you. Could very well be a win. Another possible outcome is getting the case dismissed. And there are two types of dismissals, which we'll get into in a little bit. A dismissal with prejudice and a dismissal without prejudice. And I'll go over what's the difference in a minute. And then finally, if you went all the way to trial, two options are a verdict for the plaintiff, which means that you lost, and a verdict for the defendant, which means that you won. So let's go over those a little bit more in depth. First of all, the default judgment, it's pretty straightforward. You defaulted because you either didn't answer or didn't show up to the court hearing or the trial, and the plaintiff gets a judgment by default. So you want to try to avoid that. You want to make sure you answer the lawsuit or show up to court. Don't default. It really makes their job much easier, unless you're judgment proof, which is another issue altogether. So the second outcome, like I said, is a settlement agreement, and you basically come up to an agreement with the plaintiff how you're going to pay, whether in a lump sum or in a payment plan, and that agreement is memorialized in a document either called a consent judgment or a consent order. And I don't have time in this video to go into it, but you basically are looking for a consent order. You want to try to negotiate a consent order with the plaintiff and get that drawn up and filed, and it basically outlines when you're going to make the payments, where you're going to send them to, and if you make those payments, then you have the settlement agreement in place. So you're basically negotiating a lower total amount and monthly payments in a consent order, and it just details what's going to happen if you don't comply with those payments, if you miss a payment, which is what you want to avoid, because then they get a judgment for the full amount minus whatever payments you've made. But like I said, you want to, when you have a settlement agreement, you want to negotiate a consent order, and that'll be filed with the court. Next possible outcome is getting a dismissal. So I told you there are two kinds of dismissals: dismissal with prejudice and dismissal without prejudice. So let's talk about a dismissal without prejudice first. That means that the plaintiff can bring the case again one more time. If this is the first dismissal without prejudice. Without prejudice means they can bring it again. And they basically have two bites at the apple, so they can bring it twice. They can dismiss it once, but a second dismissal without prejudice means that they can't bring it again. Okay, so the first dismissal without prejudice means they can, and maybe they will bring the case again. Same claims again. How do you get that? A dismissal without prejudice. That's really usually voluntarily filed by the plaintiff. If you put up enough of a fight, they may file a dismissal without prejudice. If for some reason they can't find you to get you served, they may dismiss the case without prejudice. If they miss a court date, they may try to dismiss it without prejudice, or the court could dismiss it without prejudice on their own behalf. Another way is if you, like I said, put up enough of a fight, or if you show up to the court date and the plaintiff doesn't have what they need to proceed with trial. If they didn't bring a witness, which they usually never bring, and if they did not bring what's called a business records affidavit, which would help them or allow them to attempt to introduce documentary evidence. If they don't have either one of those things, and you show up to court and you're ready to go forward and they're not, they may dismiss without prejudice until they can get one of those things and then bring the case again. So the second type of dismissal with prejudice, which is probably what you want more than the dismissal without prejudice, because they can't bring the claims again if you get a dismissal with prejudice. How do you get that? One of the best ways is to find a good counterclaim to their lawsuit, right? And when I mean counterclaim, when I say counterclaim, I mean a claim on your behalf that you're asserting offensively against the plaintiff. And it's usually, in a credit card lawsuit, something along the lines of the Fair Debt Collection Practices Act, or there are state law claims under the Georgia Fair Business Practices Act. There's other laws, Truth in Lending Act, UDAP claims. There's a bunch of other affirmative consumer laws, but most of them in a credit card lawsuit are going to be under the Fair Debt Collection Practices Act, or FDCPA. And one tip to remember is that law only applies to debt collectors, which are, like third-party debt buyers. So it doesn't apply to your original creditors. So if you're being sued by Capital One or Chase or Discover, an FDCPA counterclaim is not going to go very far. It doesn't apply to those creditors. So you can't really use that law, to, I guess, get a counterclaim and get the case dismissed. They're not going to dismiss it based on that. But a good counterclaim will get your case dismissed sometimes. Another way is to show up, at trial with the counterclaim. They don't have what they need to prove the case, and they can't dismiss it without prejudice because you've got them on the hook with the counterclaim. So even if your counterclaim is not solid, meaning you're probably not going to win it, but you've got that on the books and they show up and they don't have the necessary evidence to prove their case, they can't voluntarily dismiss the case. Well, they can dismiss their claims, but then they're still on the hook for your claims. So they're probably going to try to negotiate a dismissal with prejudice. So that's, the second type of dismissal. And then the other options basically are if your case goes to trial. The two options are verdict for defendant, that's you, that means you win, and verdict for plaintiff. And basically that's really probably what you want to know, when you're asking the question how to win a credit card lawsuit in Georgia. You want to know what they've got to prove and what you've got to do to beat those allegations. So when I say what they've got to prove, basically a credit card lawsuit is brought under one of two legal theories usually. It's either breach of contract, which is what it should be, because credit cards are deemed written contracts in the state of Georgia, or the other legal theory is account stated. And in my opinion, account stated is kind of a phony baloney claim, but sometimes their courts allow them to win on those claims. So let's talk about what they need to prove for each of those claims. So real basically, breach of contract in Georgia, they need to show a valid contract, a material breach of that contract's terms, and damages resulting from the breach. So they really have to prove that you entered into a contract, and this is where you really kind of want to know whether you're dealing with an original creditor, like that Chase, Capital One, or Discover, or a third-party debt buyer. This is where you can sometimes win your case, guys. So if you got a third-party debt buyer like Midland Funding or Midland Credit Management, however you want to say it, or Portfolio Recovery, or Cavalry, there's tons of them out there. If you're dealing with one of those companies, third-party debt collector, they've got a tough time proving their breach of contract case because what they've got to show, in my opinion, they've got to show the contract. And what is the contract? Under Georgia law, it says that when you get a credit card in the mail, you assent to its terms when you use it, and it creates a written contract. The terms and conditions of that written contract are what's called the card member agreement, or the credit card agreement, or the terms and whatever the document is titled. It's that packet of terms that's sent to you with that credit card in the mail. And that's really the contract. That's what determines what's a breach of contract, what the interest rate is, what state's laws apply. Everything that governs that credit card agreement is in that card member agreement, and that determines the contract. So if a third-party debt buyer brings a breach of contract case against you, ask them to show you the contract. Many times these guys don't have the card member agreement, right? They did not purchase it along with all the other documentation that they purchased from the original creditor. And if they don't have that contract, I like to argue that they can't show a breach of contract because they can't show the terms of the contract. They can't establish a contract. How should they win a breach of contract claim? So there's a lot more to it, but that's basically what you're thinking about when you got a breach of contract claim. An original creditor, which is different, they're, 9 times out of 10, they're going to have the contract, the card member agreement, because it was created by their company and they've got it in-house and they can produce it usually. So just keep that in mind also. The next theory that I mentioned is account stated. And I said it's kind of phony baloney in my opinion, because account stated is really, it goes back to Old English common law, and it's really tricky to understand, but basically it's meant to be used for when you've got an open account and you've got a merchant business arrangement, sort of a creditor debtor business arrangement where people are going to buy things on account from the merchant, right? So we can think about it in terms of in today's world where, somebody may be a construction worker or a contractor and they go buy things on an account like drywall. They go purchase drywall from the distributor or whoever sells drywall, and they purchase it on account. They go do the job, get paid for the job, and then go pay off their account, right? And they do this all the time, right? So they're doing jobs here, they're doing jobs there. They've got an account running, and that merchant, whoever's selling those goods, is keeping a tab of what goods that person, that contractor is buying. And then whenever they're coming back with the money and paying them, they're giving them the credits, right? So it's the credit and the debit, creates an account. And account stated is when you've got a prior transactions between two people. They come to a mutual agreement on the amount that is owed, and then there's a promise to pay by the debtor. So those are the elements of account stated. And really that third one, the promise to pay, is where these credit card debt buyers or credit card companies, they should lose this account stated case because there's usually never a promise to pay on behalf of a debtor when they get what they try to say. Let me back up for a second, excuse me. So they're trying to say that they established an account stated by because the original creditor sent the credit card statement to you, the credit card billing statement to you as the debtor, and you didn't object to it, thereby implying a promise to pay that amount that they stated in the billing statement. It's kind of phony baloney because nobody, first of all, the original creditor that sent out that billing statement was not attempting to state an account, right? They're sending you the billing statement because they have to under the law, and they're telling you how much to pay and when to pay it, and where to pay it. So they're really not trying to state an account by that billing statement. But there's some law that allows these debt buyers to get around the breach of contract by saying that your failure to object on an account statement is a promise to pay and states an account. One thing to keep in mind is that just because, the law says that there may be an implied promise there, but it's not a requisite. Like the jury or the judge, they don't have to conclude that just because he failed to object that there is an account statement. They're going to look at all the evidence, so they can infer that. They're allowed to infer the promise to pay. It could be an implied promise, but they don't have to follow that. So remember that. I think that's probably all I want to say on account stated. Like I said, I think it's phony baloney. I don't think they should win that because A, there's never a promise to pay by the debtor on that issue. And then B, like I said before, a credit card is a written contract in Georgia, not an open account. So they try to pull this open account stuff to get around the breach of contract theory. But at the same time, when you're dealing with the statute of limitations, they want the written contract statute of limitations, which is 6 years in Georgia, rather than the open account statement statute of limitations, which I think off the top of my head is 4 years. It's a shorter statute of limitations. So they're trying to have their cake and eat it too. And I don't think they should get away with it. But as far as I know, at this point, there have not been any Georgia Court of Appeals or Supreme Court cases to rule on whether a credit card statement can create an account stated. So I think that's all that I wanted to tell you about. Other than, well, if you go to trial, if you take your case to trial, you basically, the plaintiff has the burden of proof, right? So they've got to prove their claims. They've got to prove either the breach of contract or the account stated, and I describe what the elements are that they need to prove. Your job is to be on the defensive and to try to make sure they can't introduce evidence that's not admissible, right? So don't let them introduce inadmissible evidence at trial. And what do I mean by that? Either they're going to have a witness, which they usually don't bring, on small cases anyway, or they're going to try to enter documents through what's called a business records affidavit. And you want to object on a hearsay basis. You want to say that, these records are hearsay, not subject to any exception or exemption. No. Exception or exclusion. Excuse me. Exclusion. So the business records exception to the hearsay rule is an exclusion. It allows them to introduce things that would otherwise be considered hearsay. And that's kind of detailed in the blog post on my website. So you want to read through that. And make sure that you object to anything that may be inadmissible. The judge is not going to do your job for you, and they're not going to object. If somebody doesn't object to hearsay or object to evidence that should be inadmissible, it's going to be able to come in. The judge is not going to do your job for you, so don't rely on them. You've got to assert your rights, object to inadmissible hearsay, and you preserve your rights for appeal. Or if you're a magistrate court, there's a de novo appeal, which means you can appeal it and just get a brand new case anyway. So if you're a magistrate court, keep that in mind. But make sure, your biggest job if you go to trial is object to their evidence. Don't let them get it in. Because if they can't get their evidence in, either through a witness, which, like I said, they usually don't bring a witness, or through the business records exception, if they don't bring that affidavit, if they don't have either one of those, they really shouldn't win their case at all. They shouldn't even be able to, they shouldn't even try to move forward to trial. But if they do, and you don't object, then you're going to lose, right? So you want to object and have an argument as to why something is hearsay, why it shouldn't be allowed in, and why it doesn't meet any hearsay objections, exceptions, or exclusions. So keep that in mind. Do some research before your trial date. And you want to make sure to object to anything that may be inadmissible. Read the blog post that goes along with this video. It's on my website. It goes into a lot more depth. Do some more research. I cite the case law. I cite the statutes on there. So if you have any questions, look it up yourself, figure it out. And if you need my help, if you want me to represent you, please give me a call, 404-594-5130. Or find me online at parisifirm.com. Thank you guys. Have a great day.